Good afternoon, and thank you for joining us today. This is a panel on our different initiatives for bail system changes in the Midwest. I'm Lisa Pettis, a senior fellow with the Criminal Justice and Civil Liberties Department at the R Street Institute. R Street is a nonpartisan think tank promoting free markets and limited effective government. Prior to my role with R Street, I previously served as a prosecutor, a city councilor, and an executive director for victim services organizations and child advocacy center. I'm honored to moderate this discussion today. Just a little housekeeping. If you have any questions for our panelists, please put those in the question and answer box, and I'll read those out at the end if we have time. If you're having any issues with the video or hearing, please go ahead and put that in the chat. And just to make sure everybody knows, this is being recorded. For decades, the cash bail system has been used prominently and widely to determine whether someone could be released from jail pending trial. While it was once believed cash bail was a tool to help ensure people show up for court and stay law-abiding, researchers have long warned that it has instead created a two-class system, resulting in someone's release merely on their ability to pay rather than a flight or safety risk. For this reason, bail reform efforts have become increasingly commonplace in the Midwest, with a wide range of approaches. Today, we'll be discussing the recent bail reform efforts in Michigan, Ohio, Kentucky, and Illinois. We've invited experts who helped work on legislation in these states, and they will explain what the bail changes looked like, why they were needed, and how the opposition's concerns were addressed, or are being addressed. As you'll hear, some of these are current efforts going on. I'd like to introduce my panel to you. First, we have Aidan Cotter. He is a senior program associate at the Vera Institute of Justice with a primary focus on pretrial justice. His work at Vera focuses on legislative pretrial reform efforts across the country and includes advising local jurisdictions on sound pretrial policy that protects public safety while promoting fairness. Aidan currently participates in coalitions and legislative advocacy on bail reform in Michigan, Texas, New Mexico, New Jersey, and Tennessee. Before joining Vera, Aidan worked as a public defender for nearly a decade with both the Legal Aid Society of New York City and the Office of Public Defenders in Colorado. Aidan received his law degree from the Brooklyn Law School. Today, Aidan will be speaking on behalf of the bail system change efforts in Michigan. Micah Derry is a seasoned campaigner with nearly 15 years of public and government affairs experience and has a proven track record of advocating for sound public safety and criminal justice policies. Currently, he is the founder and president of the Adams Project. Prior to consultancy, Micah served as the state director for Americans for Prosperity in Ohio. During this time, he was responsible for fundraising, building coalitions, legislative strategy, policy analysis, and grew to serve as a foremost right-of-center voice in criminal justice reform in Ohio. Micah's earlier experiences also include serving as the deputy director of policy and legislative affairs at the Ohio Treasurer of State, a legislative aide and committee clerk in the Ohio House. Today, Micah will be speaking on behalf of the bail system change efforts in Ohio. Allison Shames is a director at the Center for Effective Public Policy, where she also serves on the organization's board of directors. Allison leads many of CEPP's pretrial projects, including the National Advancing Pretrial Policy and Research Initiative. She's also the director of the Illinois Pretrial Fairness Act project, through which CEPP is assisting stakeholders with implementing the Pretrial Fairness Act, a groundbreaking law that abolishes the use of financial conditions of pretrial release. Before joining CEPP, Allison was a justice consultant and worked with organizations and jurisdictions to implement new programs, conduct strategic planning, and author reports. Prior to that, she served as the associate director and director of programs for the Center of Sentencing and Corrections at the Vera Institute of Justice. Allison received her JD from New York University School of Law and her BA from the University of Pennsylvania. Today, Allison will be speaking on behalf of the bail system change efforts in Illinois. And last, but certainly not least, Tara Blair is a pretrial justice consultant and the former executive officer for the Kentucky Court of Justice Administrative Office of the Courts, Department of Pretrial Services. She retired in September 2021 after 26 years with the agency. Tara has extensive experience developing program missions, goals, objectives, pretrial assessments, and data management. She authored the policies and procedures for her former agency. She created the training module for new and existing staff and interdisciplinary training with the Department of Public Advocacy, state prosecutors, and the judicial colleges. Now, Tara conducts program assessment, system mapping, training, and technical assistance nationally and internationally as a consultant for various agencies and organizations. Tara has presented, co-presented, and served as a facilitator at numerous state, national, and international conferences. Tara holds her bachelor's in sociology and a bachelor's in police administration from Eastern Kentucky University. And today, Tara will be speaking on behalf of the bail system change efforts in Kentucky. First, thank you all for joining today. Very excited to have such expertise here to talk about these really incredible efforts in these states. And so I'd like to just start off by talking about what are the bail system efforts or change efforts going on in these different states. And I will start with you, Aidan.
Great, thank you. And thank you for having me here. I'm excited to talk about the bills we have pending in Michigan. It is an 8-bill package. So in order to not get in trouble with Liesl for going over time, I will focus on 2 of them that I think most directly deal with the issue of bail and release. So essentially the approach we're taking with our main bill, which is one that deals with the issue of bail setting, is I think the easiest way to think about it. There's essentially like 3 categories that judges can consider for release or for detaining a person. The first one is already in Michigan's constitution, and we're not changing that. And that allows people who potentially pose a great public safety risk based on the nature of the charges to be detained without money bail. The next category is the ones where judges can consider setting money bail. And this is one where we took really a moderate, almost common sense approach that would help deal with some of the inequity, but while not compromising public safety. And so how that looks in practice is essentially for all the offenses that just by their very nature do not demonstrate a public safety risk. So in this case, nothing assaultive, nothing of a sexual nature, not even driving while intoxicated. For those offenses, judges wouldn't be able to set money as a condition for the person to be released. There are a couple of carve-outs there, and one, deals with the concern of people getting rearrested. So for that, if somebody is essentially charged, let's take it as an example, a low-level shoplift. Under this bill package, judges wouldn't be able to set money bail. However, if that person is released and then accused of shoplifting somewhere else, the judge would be able to consider setting money bail, but again, only if there's a finding that the person is a public safety risk or a flight risk. And then there's a similar carve out for somebody who is released and then just doesn't come back to court. And then there's the third category, which is, look, if it doesn't fit into one of these top 2 categories, then the judge can't set money bond as a condition of release, but they can set non-monetary conditions. And then another big piece of this bill is that it importantly makes a distinction between simple non-appearance, which we know the research tells us the vast majority of people are missing court because of a doctor's appointment, childcare issue, employment issues. It makes judges treat those different than the ones that I think people are really concerned about, which we call absconding, which is people that are trying to, in theory, either flee or delay their prosecution. The other bill that I'll mention is one where we're trying to establish statewide pretrial services. We're really excited about this because currently in Michigan, judges really kind of have 2 options, either setting money bail as the condition for somebody to be released, or they can just straight ROR. But I think for judges, there's a lot of people maybe in the middle where they feel, it would be nice if somebody kind of had eyes on somebody in the community. So pretrial services would be able to have check-ins and kind of keep eyes on somebody in the community. But just as importantly, the way we're drafting it is they would also look to provide services that look at what is the root cause of why this person is here to begin with. Because of course, we know overwhelmingly it's issues of poverty, substance abuse, mental health struggles, and seek to connect people to services to get at the root cause of why they ended up in the criminal legal system to begin with. So again, it is 8 packages, but I'm going to stop at those 2.
Micah, can you tell us what the efforts going on in Ohio?
Absolutely. So in Ohio, we are at kind of a little bit of an in-between space at the moment. And, 2 of the states and on this panel that are represented are actually full-time legislatures. And so on one hand, you would think that means we get a lot done, right? Then on the other hand, it means that the legislature ever grinding away slowly goes in a little bit of fits and starts. So last General Assembly, the previous 2-year period that ended at the end of December of last year, we had been working on a package that would emphasize first a codification of the criminal rule 46 that Ohio has been operating from for the last few years, bolstering some of the good aspects of that legislation. But at the very last moment, we ended up with, as often happens in the legislature, we ended up with a bit of a stalemate, but we did get an agreement that we needed better data to be able to operate from in the first place. So what resulted was the creation of, and I know I'm rolling my eyes too, the creation of a task force. With the creation of that task force with a bipartisan structure is to commission and require the county sheriffs of Ohio, all 88 of them, to submit data on a daily basis for 60 consecutive days. Those reports are to help better inform how many folks are being held pretrial. And we had some great research that came out of the ACLU of Ohio that did a great job of getting a snapshot of a handful of counties. And we learned a lot of things that, for those of us who work in this space, it wasn't that much of a surprise, but certainly stopped short of being authoritative when it came to persuading particularly legislators that were skeptical of being able to make more concrete policy decisions. The most important things, though, that we saw in the last iteration of legislation and will most likely see in the next iteration is, first and foremost, setting a concrete timeline for when the detention hearing has to be held for a determination to be made by the court. The second is emphasizing other opportunities and other conditions of release than just a monetary bond. While the legislation that was introduced and we're likely to see here again does not put an emphasis on eliminating cash bail, it does put more of an emphasis on what other options are available to the court. It also does not touch jailhouse bonds. So bond schedules for the time of booking and processing would remain in place in Ohio. The reason it was still considered to be a major stride forward, and as you may guess, why prosecutors in particular were pretty reluctant to see anything progress, is because, in fact, it would have certainly emphasized those least restrictive means and that language that we've all become more familiar with, but also in making something rather permanent that previously had just been an administrative rule in Ohio's courts.
And Allison, can you tell us about Illinois, the efforts, and then also maybe a little bit about what's going on right now about its implementation?
Yeah, absolutely. Thank you. And thank you for having me today. So Illinois, it's actually very easy to explain what they've done because they passed a very comprehensive bill in January 2021 called the Illinois Pretrial Fairness Act. And it contains, I mean, it's hundreds of pages. It contained a lot of different changes. I'm going to bullet point it real quick for you. But to say that was meant to be implemented as of January 1st this year. But at the end of last year, a number of states' attorneys came together and filed litigation in the state courts, alleging that the Pretrial Fairness Act was unconstitutional on a number of grounds. That is currently pending in the Supreme Court. We are awaiting a decision. I think people are feeling fairly optimistic that the court will uphold it, and then we'll be moving forward with implementation. So just to be clear, this has not been implemented yet, but the hope is, with fingers crossed, that it will come to fruition very, very soon. And we're literally, it could be any day now that we hear from the Supreme Court. But what is contained in that law is nothing short of groundbreaking. It eliminates the use of money bond in Illinois. So no more financial conditions as a condition of release. That is kind of the major change, but it did a whole lot more because obviously you can't just get rid of money and leave the system as is. It relied on money in the past. What the legislation also does is it creates a very intentional process for preventive detention. It requires defense counsel to be present at first appearance hearings. It requires pretrial release for most misdemeanors and nonviolent felonies. and it limits eligibility and really spells it out in terms of eligibility for pretrial detention with a very strict focus on safety and the risk of flight. So not just non-appearance in court, but risk of flight. And then very carefully in terms of public safety, what needs to be proven is the threat of, a real and present threat of safety to the community. So specified list of eligible offenses, which is pretty broad, and then a very specific finding that needs to be made at the preventive detention hearing. It also, though, does protect victims of interpersonal violence by making sure that all of the relevant crimes that DV survivors might experience are eligible for pretrial detention. And it makes sure to ensure that victims are notified of all pretrial hearings and they have an opportunity to request no contact orders. So that was really carefully crafted. It also deals with responding to violations of pretrial release conditions in that it encourages the use of summons before issuing an arrest warrant for all violations of pretrial release, including failures to appear. It does outline the use of electronic monitoring as a condition of release. It allows for, but does not require, the use of a pretrial assessment tool. And it also creates a statewide division of pretrial services. So before the change, and that change, pretrial services was really mandated by the legislature years ago, decades ago, but it had only been implemented in, I don't know the number, but I would say, a dozen or more counties. And there are, how many counties, Tara, there's 209 counties, I believe, in Illinois. So 102, okay. I knew I was close. But now pretrial services will be offered by the state in all of the counties where it didn't previously exist. So that was a really great change as well. And I think I'll stop there. Pretty comprehensive changes. We are waiting on bated breath on the Supreme Court ruling, but feeling very optimistic.
And so while Michigan and Ohio are still working to do some bail system changes, and Illinois has essentially passed it, but not implemented it, Kentucky is our one state that actually has passed bail system changes. So Tara, can you please tell us about those?
Yeah, and it's been a while. Kentucky actually started in 1976 by outlawing bail bonding for profit, so there was no commercial surety, and established a statewide pretrial services agency way back then, almost 50 years ago. But the biggest legislation occurred in 2011. And what that did is it basically eliminated money bond schedules, as Micah referred to as the jailhouse schedules. It eliminated those, and it required judges to consider a pretrial assessment in their decision making. And it put it didn't eliminate money, but it put restrictions and like a less reliance on money bond in that decision. So by using the pretrial assessment and then requiring judges to state their reasons on the record why they're setting a financial condition of release. It also required a second look at individuals who a monetary condition of release was ordered by the court. If they weren't released within 24 hours and then 48 hours later, then the courts would relook at that individual to see if there's other non-financial conditions of release that are more appropriate. And one of the big reasons why this legislation was initiated was it was the opposite. It wasn't really to improve pretrial release rates, but more of to keep the right people in jail, because with the bond schedules, especially domestic violence cases, people were able to be arrested and post a monetary bond within minutes of being booked in and then being released without any conditions at all. And essentially a judge wasn't reviewing anything. It was basically like the jailhouse schedule. You get arrested, you're charged with this, you pay this money, you get out. So that was more of the reason for the initiative. And it was a bipartisan bill. I mean, it was both sides participated in it, and it passed. More recently, there have been several bills that have been introduced, but they've died. And usually it was because both sides would add things to it. So the policy was, hey, let's do something similar to Illinois, maybe not all the way, but sort of eliminate money altogether and have like a preventative detention statute or possibly a constitutional amendment. But again, things were added in so that all of those bills have died. But Kentucky is still operating under the legislation that passed in 2011, and so far so good. So I'll stop there and wait for the next question.
And Tara, I'm going to volley it right back to you. So you kind of started talking about why the changes were made and why they were needed. Can you dive in a little bit more? You said that, you know, part of it was people actually getting released. You wanted to make sure people were staying behind bars if they needed to be. But what was the kind of thought process behind who gets released and why that might be needed too?
Well, again, you know, it was all about putting these decisions in the hands of judges, right? Instead of just a schedule. So again, it required judges to look at and individualize release decisions as well. It's looking at that individual and all the factors to that individual to make a decision, and then also to set conditions of release. Of course, it should be individualized and least restrictive, but it allowed judges to have that discretion, so to speak, as opposed to just a money bond schedule that anyone could post.
And since you do have some data, can you tell us a little bit about, has there been success based upon these changes? What have you seen come out of that?
Well, there's two parts. I probably should have mentioned this earlier, so excuse me for missing this. But also in more recent years, we had some court rules that were passed by the Supreme Court that allowed for expedited release of specific individuals charged with mainly nonviolent, non-sexual misdemeanors, low-level felonies that score a specific score on the assessment tool, can be released quickly by pretrial services officers. So that's one court rule that changed, again, to expedite the release of who should be released. But I actually got data hot off the press. I got it last night. I still have friends that work in Kentucky, so I put in a formal data request. And I can say that I believe that the policy changes in the legislation is still successful. When you look at individuals that were released pretrial, and this is for calendar year 21 and 22, 86% of people released from jail were not charged with a new crime pending trial, and 77% of them made all court appearances. It may sound low, only 77%, but again, this is everybody that's released, and there's 257,000 people that were released from Kentucky jails in those 2 years. So 77% means, you know, basically 197,000 people made all their court appearances, and over 220,000 were not charged with a new crime. And I actually want it even deeper. If you look at the type of charge that the individual was released on, people that were released on person felony crimes, they were released from custody pretrial charged with a person felony crime. 90% of them made all court appearances, and 89% were not charged with a new offense. So, you know, I see that as success. Unfortunately, everyone looks to the bad things that happen, you know, the anomalies, you know, something bad happened when someone was on pretrial release, and they want to focus on, you know, that one bad incident, when really we need to be looking at the 220,000 other people that were released and didn't reoffend and made all their court appearances. So again, I think it's also the perception of what's happening when the data shows a whole different story.
Those numbers, in fact, seem the same, if not better, than what is under current bail standards in a lot of states. So that's great. Micah, if you could also add in, I know that one of the things in Ohio being discussed was not just the release, which was an important part, but also making sure that the right people remain detained. So can you talk a little bit about why the bail system changes are needed? I know you touched on it a little bit already.
Yeah, the bright line that for legislators that continually rose to the forefront was for the snapshot that we had of Ohio's county jails, was that 2 out of 3 of those detained were pretrial, not convicted of the crime for which they were being held for. And while that in and of itself didn't necessarily raise the eyebrows, what followed did. The 2 most common crimes that they were being held for were minor possession and driving on a suspended driver's license. And that's what raised the eyebrows for legislators going, wait a minute. And especially when they realized that even if guilty, that we were talking about crimes that wouldn't ordinarily have time associated with the sentence, rather probation and fines, except for in that phenomenon when someone couldn't make bail, and we see that addendum onto their sentence of "and time served." And that was the challenge that for so many legislators was difficult to find palatable. But on the flip side of that, and this is where we get that ongoing narrative battle, we have so many instances in Ohio, and it's every few months we'll have a particularly audacious one that will show up in the newspaper, and that is where someone committed a violent crime while out, usually on monetary bond. And that's the challenge of what we have to be able to wrap with, to understand, one, be able to differentiate between bail and money bail for the layman who doesn't work in the advocacy space, but also to be able to say, okay, what are the tools that are available to the court to be able to mitigate that kind of risk? So in Ohio specifically, and where we ended up at the very end in negotiations, one was to recognize that judges need to have the tools available to them to be able to preventively detain someone, that there is clear and convincing evidence that they are a risk. Now, in Ohio, by our state constitution, we're only restricted to felonies. So if it's a felony, it is eligible for preventive detention. The legislation that came very close to passing the House last General Assembly would have drastically expanded what felonies are eligible. Right now, in Ohio, right now, it's only limited to about 7 felonies. I think that what we'll see reintroduced in the future here in Ohio will probably expand that to most violent felonies, and we might see some others as well. The other thing that often is a key distinction, because again, if we're trying to protect public safety, one of the loudest examples that we see repeatedly is in cases of domestic violence, especially when we're talking about so many domestic violence cases are actually only a misdemeanor, especially when we're talking about that first offense. The Ohio legislation would have treated misdemeanors involving sexual or domestic violence crimes a little bit differently, in that instead of having that same shorter time frame that required a detention hearing, it would provide an additional 24 hours for further finding of facts for law enforcement and for the court. Ultimately, what I think we're going to see reintroduced in Ohio, and what will probably have a little bit broader support in the legislature because of all the great work that went into last General Assembly, is more of that bright line of understanding the difference between violent and nonviolent defendants. And perhaps most importantly, the continued awareness that is growing in Ohio amongst our policymakers that money bond isn't what keeps us safe.
And Aiden, I know one thing that's similar between Ohio and Michigan is one of the top offenses that people are getting arrested on are driving with an invalid license. So I'll go to you next and just say, what is the impetus or the push for bail system changes in Michigan?
Yeah, that's exactly right, Liesl. And Micah mentioned task force, and that was really the impetus there in Michigan. Is there was a bipartisan task force put together to really study the pretrial and jail system. And there's a lot of alarming findings. A couple that I'll mention is they found that, just similar to what Micah shared about Ohio, almost 2/3 of people in the local jails were there pre-trial, right? So they haven't yet had their day in court. They are presumed innocent. And just as troubling, of those folks, about 40% of them were there because they couldn't afford a bond of $2,500 or lower. Michigan happens to be a state with a very active bail bond industry, so that effectively means that people didn't have a few $100s to bond out. The other thing that a $2,500 bond tells you, and I draw upon my experience of almost a decade as a public defender, if a judge is only setting a $2,500 bond, you're likely not a public safety risk. That's a very low bond in Michigan. And the other concern was there was kind of like a one-size-fits-all approach, where judges were treating the most minor of offenses, like the driving on a suspended license, identical to the most serious offenses, which is not good for public safety, because the limited judicial resources, in effect, what they saw was judges almost rubber stamping arraignments, and almost everybody was getting some sort of monetary bond, and it was based solely on the charge. And so our approach in Michigan is by taking those low-level offenses that we know are just not a public safety risk, we've now freed up a lot of judicial resources for those judges to look at those cases on the margins where maybe there is a public safety threat and actually be judges on those cases.
And Allison, what about in Illinois? What was kind of the push to change the bail system there?
So I think a lot of what's been said was the case in Illinois too, and it really is the case around the country. The default system for pretrial in most places is the bond schedule, setting a bond. It's up to the financial means of the person, whether they get out or not, with no consideration of their risk to the communities or their flight risk. And so I think that remains sort of the biggest driver, I think, across the country and also in Illinois. I think the numbers are the same, 90% of the people in jails in Illinois are awaiting trial. It's a very, very similar situation. And I just want to emphasize what it really, I think all of us have been saying here is that despite our long time use of money bonds, they do not produce public safety, right? Regardless of the danger that someone may pose to the community, if they have the money, they can get out. So money bond is no assurance that the person can be detained. And once they get out, it really doesn't deter anyone's criminal behavior. That money is not going to be forfeited if a new crime is committed. And there is no research that I'm aware of that demonstrates that a money bond deters new crime. So the most definite way to protect the safety of the community is to have this intentional system of preventive detention that you've heard us all talk about. That is where the judge will decide, based on evidence, based on both parties presenting evidence, that a person needs to be detained because the judge decides that there are no conditions that can reasonably assure public safety. That's our standard that exists in really almost in every state. The other side of it that was of great concern to people in Illinois, of course, is that locking people up who are very likely to be safe to release compounds that public safety danger, right? So not only is it very unfair and inequitable to lock people up because of the lack of their wealth, but we also know from research that basically spending time in jail when you're kind of a law-abiding person for the most part, or I shouldn't say law-abiding, you're there because you have been arrested, but you are someone who can safely be released. You will be part of that 80% that Tara mentioned that would safely come back to court. What we know is that those people, when they spend time in jail, it's a criminogenic factor. They are going to get out of jail and they are more likely to rearrest and all of a sudden become part of that 20% that Tara is mentioning. And those numbers are pretty nationally, right? 80% of people will be successful generally is what we know. So we have this long held belief that keeping people in jail equates to safety, and it just doesn't. Jail is the right place for some people, but not for the large numbers of people that are there for pretrial. So that really has become a big driver. And I think, of course, the fairness and equity of it, using money bond, and I think eliminating money bond in Illinois, and hopefully what we'll see in other states, something that doesn't get mentioned as much. We all know about the inequity of it, but what's something that doesn't get mentioned is that when you have a money bond system, there is an enormous wealth extraction from the communities who are most vulnerable, right? They have to pay money to get out. And the people paying the money are the people who have the least amount of it. And being aware, I think, of that wealth extraction, to me, really tells us it's not a system that we should be relying on. It's not effective. It doesn't protect anyone. It does not assure appearance. And it takes money out of the communities that most need it. And, as well as the other points that Mike has mentioned as well, that people are sitting there and they wouldn't even necessarily be subject to a jail sentence if they were found guilty. So the reasons are really compounded, I think, when we talk about the dangers of money.
So you all gave some pretty compelling reasons to change the system, but obviously there's a lot of opposition. as well. And so, Allison, I do want to start with you on that, because the opposition in Illinois actually turned it into a lawsuit that is now at the Illinois Supreme Court. So could you just talk about kind of what the opposition has been and how you try to dispel any of those like myths or misunderstandings there?
Yeah, absolutely. The opposition was very, very vocal in Illinois. But just to be clear, the case that's pending in Illinois is really, some of it is more technical, like whether the legislature kind of acted in the right way and whether it's consistent with the separation of powers. And part of it is around the elimination of money. But the opposition, that was kind of a means to an end. The opposition wanted this law to go away, and so they found reasons to bring the lawsuit. But what the opposition really was about, what were concerns about violent offenders being released, concerns about people being released in mass numbers. But I want to be crystal clear about a few things. The new law in Illinois will better protect communities for all the reasons we just mentioned. People who are arrested for violent crimes, they are eligible for pretrial detention in Illinois. So they won't all be released. They will be detained once a judge makes a decision that they should be detained. That will get us to better public safety. I have no doubt about that. And let's also be clear about how the current system operates. People are complaining that this new system will be dangerous, but the current system works in a way that lets out people who can pay the bond. The new system will assure that the right people are detained and the people who can be safely released will be released. And also something that we really are crystal clear about, the vast majority of people, like Tara mentioned, of people who are released, they are successful in their pretrial period. They come back to court and they do not get rearrested. That number of 80% is really kind of this national average that we see, and same with the appearance rates. It's an exceedingly rare occurrence that someone's arrested for a violent crime while on pretrial release. Does it happen? Yes. The hope is that using preventive detention, where you actually have a hearing to examine the person and the circumstances, will actually better capture that. And that maybe that rare occurrence will be even more rare under the new system. I also want to be clear, sorry, about one more point, is that under the current system in Illinois, again, only about 17% of people are detained in jail pretrial. Those are numbers that we know. And the vast majority are released. In some counties, that percentage is even lower, right? Closer to 10% of the people are detained. We hope and expect that that will probably actually remain about the same. The difference may be that who is detained could be a little different. It's going to capture the people who are most at risk of hurting someone. That's who we want to detain. So I just wanted to also say the experience we know in New Jersey that has changed their system, it's been incredibly successful. Crime does not go up when money bond is eliminated. So these were some of the concerns we heard. And unfortunately, they got hold of the narrative, especially in the media. But crystal clear, the facts and the evidence, this will be a safer Illinois if this law is implemented.
And thank you for mentioning New Jersey. For any attendees who have not looked into New Jersey's bill system changes, they really are kind of, I think, a gold standard that people look to. We focus very specifically on Midwest here, but it is a great policy kind of look at. Aiden, I want to go to you next. I'm sure some of the opposition is similar, but the policy is different. So, some of those might be a little bit more nuanced or very similar. But if you could talk about some of the opposition you've seen in Michigan, as well as just how you try to address some of that.
Yeah, thank you. This is kind of a tough one to answer because, of course, there's been a lot of opposition. But I think it would be fair to say a lot of the opposition does not come across as being particularly in good faith that are actually match up to our policies. I would say, there's a lot of fear mongering, and we started trying to push this package through in 2021, which, as we all know, very different climate from trying to do something in, like, let's say 2019. Post-pandemic, crime went up in a lot of places. And I think you combine that with a lot of the irresponsible media coverage of bail issues nationwide, and it's definitely made a tough climate. And that's a big part of why our bills, the approach we took was very thoughtful and narrowly tailored. And so that's where I get to a lot of the opposition that we hear just frankly doesn't match up to our bills. I'll give you kind of a couple of examples. The one thing when we go into different lawmakers' offices, they like to talk a lot about is shoplifting. And the idea that if we pass these policies, there's going to be, I think, smash and grab is the tag phrase of the day. But, as I mentioned, when we talk about these bills, one kind of way we try to address that concern is if somebody is rearrested for a similar offense, the judge then would be able to consider money bail. So that kind of gets at that concern that they're speaking of the revolving door. We also hear things where, okay, yes, you're saying shoplifting is minor, but sometimes people kill people while shoplifting. Yes, but like our bills don't, we're not saying in that circumstance, people just get released. So a lot of it really doesn't match up to the policies. I think one thing we of course see is that if these policies pass, even though they are narrowly tailored and moderate, is they would impact some of the financial profit from the bail bond industry. And so we definitely see them making the rounds and spreading, different misinformation that, just like Allison said, has been debunked, that this idea that somehow a monetary bond protects public safety, which we just know isn't true. And the one other piece I will hit on is just we're running into a lot of, the political calculus for a lot of electeds is that they need to return to this kind of tough on crime rhetoric. And how do we navigate that at a time of trying to push these reforms?
And Michael, what about in Ohio? What was kind of the opposition last year, or what's the opposition you anticipate going forward?
Yeah, despite the microphone, I don't have the crooner voice, so I won't try to belt it out. But I mean, the story was New York, New York, New York. I mean, that's what we heard everywhere that we went. And I don't think that's unique to Ohio even. A lot of people, given the media presence that comes out of New York, both regionally and national, given the both warranted and unwarranted critiques of New York's policy, it made for a very, very powerful narrative that is very difficult to push back on that directly. And honestly, in lieu of data, and during the early days after passage in New York, it was difficult to even dispel back on some of the nuances around the warranted and unwarranted narratives around New York. And as such, it just made it that much easier for prosecutors and for bondsmen to say this is New York policy. There's just enough similarity that they felt that they could make that case. And again, remember, when we deal with legislatures, very few of the legislators are actually in any way a practicing attorney, or let alone read in on criminal law or pretrial practices. And as such, we often expect that just because someone works in the policymaking arena, that they're going to have a deeper knowledge and understanding and be able to appreciate some of these nuanced differences. And frankly, they don't. And so the number one opposition issue that we have to encounter is the issue around narrative and understanding that that's not something that just goes away, and something that we have to be able to tackle and do it aggressively. I think that some of the opposition that we will continue to see is largely going to be based off of just people not understanding some of the fundamental aspects. I talked about legislators that are not experts in this area. Sometimes you will have something that even a legislator who is very up on a lot of criminal law issues may have a fundamental misunderstanding of how bail works. We encountered this in Ohio, and he's an excellent legislator and an attorney, and so I don't want to throw him under the bus by throwing out his name, but he learned for the first time ever, that bond agents often don't end up forfeiting the bond if their client does not appear. And furthermore, he didn't realize that's not always 10% that is paid by the defendant to the bond agent, and that number can actually fluctuate wildly. My point is, even someone who has a wonderful track record on the issue and decades of experience working with the policy field may not know. So the number one opposition is not necessarily an entity or an interest group that's working against us, or maybe even a specific argument. It's just people not knowing. And that's the number one thing that we have to be able to overcome.
I think that's a very fair statement, that the bail system itself is complex, and then you get into the legislation to change it and it gets even more complex. Tara, I'd love for you to kind of chat. I mean, obviously this was years ago that Kentucky first implemented bail, but has there been opposition over the years? It sounds like, if anything, more recently people have wanted it to go further. So if you could talk a little bit about that, and then also if you could kind of loop in, with the bail reform that happened in Kentucky, how was public safety addressed? And then we do have a question about whether or not there's pretrial support provided for people who are released. So if you could weave that in.
Well, and initially the main opposition, actually, again, just like Micah said it beautifully, it's like people just don't know, or they don't want to actually read the statute to know what it means. And then there's this perception that it's taking away judicial discretion because they were required to consider an assessment, that it was somehow taking away judicial discretion. So that was like, in the beginning, that was like a huge, like, we shouldn't have this, it's taken away. But it's the exact opposite. It actually gave judges more discretion by eliminating bond schedules and requiring the judge to make the decision. So that was early on, that was a big pushback, was just that taking away judicial discretion. And then we got through all of that. But then what next, which actually was interesting, because Kentucky had an assessment that was being used that was validated, and research was done, it was solid, but it became into question. So it's like, okay, if we're going to have to consider this assessment tool, we don't trust it, right? We don't like the tool. We want to know more about it. So actually, I think something positive came out of that, was that as a pretrial agency, we were able to reach out to it's actually the public safety assessment, which Allison and her work with APPR, they didn't exist then, but Kentucky was the first state that moved towards that tool, which is now used nationally. So I think it helped with that pushback. Well, we don't really trust this data to be able to say, hey, we've got this, we've got PhD people coming in, looking at the data, creating this to help with that opposition. So I think that was important. And then moving forward, I think when I said that they're wanting to take it a step, nothing's happened. I just know the bills have been introduced, but there has been a big movement recently. And I hate that I'm not part of it. I haven't, because again, I retired from there in 2021, but as I was leaving, there was a really push towards more supportive services. And because Kentucky and Ohio, you're going to see the same thing. Southern Illinois, same thing. Probably Michigan. I'm not as well schooled in Michigan, but just the opioid crisis, substance use disorder, overdose, fentanyl is huge. People are dying. So there's this movement towards this like recovery system, oriented system of care for the courts, more offering supportive services to people, especially those that have substance use disorder. Can I answer in the data I gave you how many of those? I don't have that. Kentucky does have a really good model of pretrial support. They have text court notification for every single person. They do have peer support specialists throughout the state. Some are stationed in courthouses and courtrooms. Some are working directly with individuals that are released. But I don't know of those 220,000 that came to court or didn't get rearrested. I don't know which specific ones had those supports, but I do know that that's the trend. There's actually legislation that just passed last year after I left. They call it Senate Bill 90, that sort of like expanded on some of the diversion options to allow more treatment and diversion programs for individuals. So I know that's the trend is now we've got a good pretrial structure, a statewide pretrial structure. So now let's try to do better and try to actually help people that have because our unique situation in the opioids and the overdoses and I live in Kentucky. I don't work, but I still live, but we're facing with. So I hope I answered that question.
Yeah, thank you. And we have only just a couple more minutes because I want to make sure we get to at least one question already in there. And if other people, please, if you have questions, please throw them in the Q&A. So for the rest of our panelists, if you could just name a couple of the quick things of how is the legislation that is being proposed or likely going to be proposed really looking at how to address public safety? If you could just mention some of the high-level things of what's being done for that. Aiden, you can go first.
Great, thank you. And I'll keep it brief. I see time. Yeah, so, again, being very aware of the climate in which we are trying to push these bills, we have been very focused on public safety in our messaging. Of course, the offenses that we carve out as not eligible for money bail do look at whether there's a public safety risk or not. I would note that we have spent countless hours speaking with victims' rights groups, DV groups, prosecutors, law enforcement to make sure that's all represented in the bills. And we also just try to really get that message across that Allison was mentioning of we're starting from the wrong baseline if we're starting from the presumption that jails are actually good for public safety, because what we know is that they're not. And really trying to educate that, look, if somebody is detained pre-trial for over 24 hours, because of the fact that their life has now become likely destable from losing their job, losing their housing, maybe their kids have been put into state custody, that now they're actually more likely to get rearrested in the future, and that's not good for public safety. And then the other thing we really make sure to message is that we think providing pretrial services in a supportive manner is a good way to get at the root cause.
Micah, what about in Ohio? What are some of the things for public safety?
Yeah, I think that the thing that can often be challenging to remember as advocates is that sometimes there are distinctions that matter more in public opinion and amongst legislators than maybe what data bears out. And often the best way to be able to delineate that quickly is recognizing differences between violent and nonviolent. It is not, that's not surgical by any means, and it is fraught with problems. But it's certainly a better instrument and tool than saying felonies versus misdemeanors, especially when we're talking about from state to state. It's really walking in with a lot of patience and recognizing that anything that is passed in any state is not going to be perfect. And looking at how can we get to a more perfect, not a perfect system. So in Ohio, a lot of the focus is going to lie on the difference between violence and nonviolent.
Allison, in about a minute, if you could talk about some of the pieces put in for public safety with the bail system changes.
Yeah, I mean, I think it's similar to what the others have said. I will say that one of the amendments that was made in December of 2022 was that it expanded the list of offenses that were eligible for pretrial detention. And I think that was very responsive to fears of public safety and probably reached the right balance for Illinois. And I think leading into pretrial services as well, not just for its monitoring and sort of compliance focused, but really, as Tara said, trying to help people and support people in this difficult time and giving them the tools to succeed and hopefully not come back into the system. So I think those were some of the major things. And as Aiden said, involving survivors and victims in the process itself. They've been advocates for the law. They played a hand in the creation of the law. And I think having them in that process, not at the end of it, was really important to be responsive to their interests.
So some of the things I loved is it sounds like a lot of people did a lot of key stakeholder meetings with both victims, law enforcement, prosecutors, which can be hard because they may be very against the legislation, but very important voices to hear. Some states are doing expanded preventative detention. Some are doing statewide pretrial services, but all of them, it sounds like, are really making this distinction between violent offenses and making sure that those may still be detained versus these lower level offenses. We do have a couple questions that have come in. Some are very specific that I will probably send out to the panelists, and then we can send those answers along with the recording. But there is a question here about racial disparities. And if anybody would like to try and tackle that, in particular, this person has mentioned that in New Jersey, while it is touted for really having some successes with bail reform, that there does still seem to be some persistence with racial disparities. And so if anybody has an answer to kind of address that piece.
I can jump in and then I'll hand it over probably to Allison or but you know, I do work all over the country, and places that have bail bondsmen, places that have preventive detention, places that have bond schedule, but racial disparities exist every single place that I go throughout the country. It's there. There's a disproportionate number of people of color that are in our jails, that are in our prisons. I personally don't think that has anything to do with bail reform, because it was there before bail reform. It's there now. And unless we make systemic changes, long-term cultural, systemic, I don't see it going away. I want it to go away. In a perfect world, I wish we could eliminate that. But every single place I go, regardless of what their pretrial system looks like, I see disproportionality and disparity.
Yeah, I'm happy to jump in very, very quickly, which is to Tara's point, this starts with over policing of certain neighborhoods, which brings different people into the system to start. So if you have disparities from the very beginning, those disparities are going to persist along the way, including in your jail population. So in New Jersey, remains a big problem. It's a focus of the judiciary. It's a focus of the legislators. I think legalizing marijuana will make a huge difference in the years, because people were arrested on the possession of small amounts of marijuana were disproportionately people of color in New Jersey. So I think those numbers are going to improve, but it also remains a focus. But it's two different issues. All the reforms we're talking about are great, but you still need to address who is coming to your system in the first place, and then overcoming any implicit bias that might exist, and any, overt bias as well.
Yeah, I think I'll just jump in plus one, the notion that really we need a systemic approach to this. I think when I think of issues of racial disparities in bail setting, it's often, I personally like some of the policies that take a bright line and say you may not set money bail on certain offenses, because that helps eliminate that implicit or explicit bias. But that's not the silver bullet. We've seen that in New York. And I think because, well, another, actor in the system would be prosecutors. Who are they choosing to charge with what, and whether that offense and that charge is elevated. And so implicit bias can come in at that level, and of course at the policing and arrest levels. So I really think it absolutely needs to be a more systemic approach to hit each level of the system.
We have about 1 minute left. If anybody has any quick questions, please feel free to submit those. There was a question about bill numbers. We can send those out later along with recording. Also, list of eligible offenses for pretrial programs, which I will chat with the panelists to see if they have some information that we can send out as well. And I will put up a slide just with my contact information. So if anybody would like to reach out after this panel to get some additional information, I can also get you in touch with any of our panelists who are here today. So please feel free to reach out about that. But I don't see any additional questions at this point in time. So just want to send a quick thank you to all my panelists today. Really appreciate not only your knowledge on the subject and sharing that with everybody, but the work that you're doing in in those states that you're participating with. And thank you, and everybody have a great rest of the day.